just dive right into it. What is going on with that lawsuit? Can you give us a little bit of background?
Sure, absolutely. Yeah. So this case originally was known as Missouri v. Biden, and then the appeal to the Supreme Court on the injunction, which was what happened a few weeks ago, that case is known as Murphy v. Missouri. But the background on this case is that 5 private plaintiffs, myself, my colleague at Stanford, Jay Bhattacharya, my colleague Martin Kulldorff, formerly of Harvard, they're well known for having co-authored something called the Great Barrington Declaration that was in favor of focus protection and opposed to lockdowns, school closures during COVID. And 2 other plaintiffs, a woman named Jill Hines, who runs a health freedom group in Louisiana, and a journalist named Jim Hoff. We've joined 2 states, the state of Missouri and the state of Louisiana, suing the federal government for alleged unconstitutional suppression of First Amendment free speech, specifically on social media. So what we're alleging, and what documents that we've retrieved so far on discovery are showing, is that the government has been coercing, pressuring, manipulating, leaning on the social media companies to do their bidding, specifically to suppress speech that the government considers to be a threat to their agenda, basically. And the private plaintiffs originally were submitting information to the court related to being censored because we were critics of the government's preferred pandemic policies. And so a lot of the initial evidence we submitted to the court was related to censorship of basically disfavored opinions on COVID and critics of the government's COVID policies. And we had some evidence as well of election interference on the part of the federal government. So it was mostly COVID and election. But one of the things that's happened, Nicole, is we got more and more documents on discovery. We have 20,000 pages now of documents of basically communication between the federal government and the social media companies. We've done 6 full-length depositions, which are of various defendants, which have provided also invaluable information. What we discovered is actually the federal government, not only have they been censoring and pressuring social media companies to censor, but they've been doing it on a range of topics that went far beyond just COVID and election integrity. So they've been, the State Department was involved in censoring people who were critical of our foreign policy, people who are critical of the support for, monetary support for the war in Ukraine. People were critical of the way in which we withdrew from Afghanistan. The Treasury Department has been censoring people who are critical of the federal government's monetary policy.
Right.
You take any lightning rod issue in American public life, including domestic issues like abortion and gender ideology, the federal government basically had its thumb on the scale and was trying to, through various complicated mechanisms that we can get into in the course of our conversation, was trying to literally control the flow of information online and control what Americans saw in their social media feeds. 85% of Americans today get their news either from social media or from click-throughs. People follow people online and then someone shares an article and say, oh, this looks interesting. And so if you're able to take basically the 6 most influential social media companies and exert control and force over them, you can be remarkably effective now at controlling what people see. And one of the things that I'm trying to help people understand in regards to this case and the significance of this case is that many Americans think, well, I'm not like Nicole. I don't have a podcast. I don't maybe have a really active social media account online. Maybe I have a Facebook account or a Twitter, an X account, but it's mostly to follow other people and see what other people are saying. So I probably haven't been personally impacted by this because I probably haven't been censored by the government or by the social media company at the behest of the government. But actually, one of the things that the Supreme Court has made clear in previous First Amendment cases is that the First Amendment right of freedom of speech exists not just for the speaker, not just for the person who's putting their opinions out there, putting information out there, publishing things. It exists for the listener as well. And one of my colleagues and friends and co-plaintiffs in the case, Jay Bhattacharya, someone you probably know well, he's got a podcast and a publication called The Illusion of Consensus. And the significance of the title is, during COVID, because of censorship and propaganda, the public, by and large, unless they knew where to look specifically, it was very hard to find information that contradicted the government's preferred narrative, even though there wasn't, in fact, a scientific consensus on things like school closures or lockdowns or vaccine mandates or safety and efficacy of the novel mRNA products. People got the illusion of consensus because the government was so effective at controlling what you were able to see and what you weren't able to see. And the ways of doing this, again, which we can get into later, if you're interested, are very subtle. They're such that if you are being censored, you don't necessarily realize that. You don't necessarily know that. Sometimes you are. Okay, my video was taken down off of YouTube and I got a strike on my account indicating that, you know, if I do this 2 more times, I'm going to be demonetized and deplatformed, kicked off this distribution platform. But very often it was operating through more covert and subtle means, things like shadow banning or deboosting of your information and search priority results. So if someone did a search trying to find you, it would be very, very difficult. Or, you know, I could put a tweet out there on Twitter, and maybe it was seen by 90% of my followers, which sounds pretty good. That sounds like a pretty significant reach. But if the algorithm made it such that the 10% of people who didn't see it were precisely the 10% who themselves had the largest following, they could control whether or not that information could catch on and gain traction and potentially go viral. So one of the observers of what's been going on with this so-called censorship industrial complex is a novelist named Walter Kern, terrific thinker. And he had what I think is the best metaphor to describe what the government's been doing. He said it's sort of like they're mixing a record. So imagine, you know, an engineer at the soundboard, and he's got very sophisticated AI that's scraping the internet, scraping the major social media companies all the time to see which ideas are gaining traction and taking hold and threatening to go viral and which ones are not. And if there's some idea that he doesn't like, he can actually reach over to his, you know, algorithm dial and turn the volume down on that. And we have evidence we've presented the court and Murthy that the government has succeeded not just in getting individual accounts taken down, but succeeded in getting the social media companies to change their terms of service and change their algorithms, which is how you get hundreds of thousands of Americans being censored tens of millions of times. So you got this, you've got this control mechanism where I could just turn the volume down on the snare drum, right? We don't like that idea.
Right.
We want to make sure, well, a few people can see it, but it's not going to take hold and really spread. And maybe there's an idea over on the other side that we want to grow organically, but it's not of its own accord, of its own steam. So we can actually just turn the volume up. You know, we've got to have more cowbell. So we'll turn the volume down on the snare drum. We'll turn the volume up on the cowbell, and we'll get the presentation of information to the American people that we want. This is a form of mind control, really, when you stop and think about it, because the digital realm is the new public square. Through these behind the scenes backdoor, largely invisible mechanisms of control, you can have profound influence over the thoughts and the behaviors of the American people, including, you know, their voting patterns and their personal life decisions related to their health and so forth. So getting back to the Murthy case, we have presented so much evidence to the court, and you're a lawyer, so you'll understand this, but I'll explain it to the audience. We petitioned the court even before the case went to trial for something called a preliminary injunction, which is basically, we've got so much evidence already on limited discovery that we think the court, rather than waiting the 2+ years it's probably going to take for this case to finally wend its way to a final decision and through all the appeals and everything else, we think the court needs to intervene now to stop the government censorship from happening. And, you know, it's a pretty high legal threshold to get a preliminary injunction. You can get denied an injunction request, but still prevail in the final ruling. That's not unusual. So we have to show that there's going to be irreparable harm to the defendants or people who are similarly, or to the plaintiffs rather, people who are similarly situated. If the courts don't intervene immediately to try to put a stop to this, and the district court judge issued a 155-page ruling last July 4th. I think he deliberately did it on a federal holiday, which is very unusual to drive home the point that this is a really important issue for civil liberties in America. And he granted our request for a preliminary injunction against 5 of the federal agencies that we had named as defendants: the White House, the CDC, the FBI, the Surgeon General, and a little-known agency called CISA.
Thank God.
The government, yeah, thank God, exactly. It was a terrific ruling, and he said some really astonishing things in that ruling. He said, for example, if what plaintiffs allege is true, and by issuing the injunction, he indicated, looks like it's probably true. One of the criteria is it's likely the plaintiffs will prevail in the merits of the arguments. If what plaintiffs allege is true, this is the worst free speech violation in United States history. That wasn't me saying that. That wasn't our lawyers saying that. That was the federal judge saying that when he looked at the evidence that we had submitted to the court. He used language along the lines of, it appears that the government has set up a dystopian Orwellian ministry of truth. Anyone who's read George Orwell's classic 1984 will understand what that is a reference to. And the government obviously didn't like the court stepping in and saying, stop, you can't do that anymore. You can't coerce social media companies to do your bidding. That's a clear violation of First Amendment free speech rights. So they appealed to the circuit court. The Fifth Circuit upheld that injunction. They narrowed it slightly, but upheld the key provisions in that injunction, a 3-judge unanimous panel there. So far, we're 4 for 4 on federal judges. The district court judge, a 3-judge panel at the Fifth Circuit, upheld the injunction. And the government appealed again to the Supreme Court. So just a few weeks ago, of course, I mean, they can't take no for an answer. So they're going to take it all the way to the top. So I was at the Supreme Court a few weeks ago with some of the co-plaintiffs and obviously with our lawyers, where we had oral arguments specifically regarding the injunction. So the Supreme Court should come out with a final ruling most likely at the end of their term in June. And we're hoping that the court will do the right thing and agree with both of the lower courts that the injunction is warranted. Regardless of what the Supreme Court does, this is not a final ruling in the case. The case will then go back to the district court for the trial phase, where we'll get additional discovery. We'll get additional information on exactly what the government has been doing. We'll be able to depose. We'll be able to cross-examine basically many more of the individuals and agencies that have been named as defendants. So I think this is important not only to have the courts intervene and hopefully put a dent in the government censorship industrial machinery, but also to educate the American people, first of all, that this is happening, the scope of what's happening, and why it's important, why something that most of us, I think for most of our lifetimes, whether on the left or the right, this has never really been a partisan issue in American history. Why most of us probably take First Amendment free speech rights more or less for granted. It's, I think, up until the last 4 years, very few Americans had the experience of being censored either by a private company or by a private company at the behest of the government. You can have all kinds of legal debates about whether the social media platforms themselves, acting alone, should be able to censor. My view is that they shouldn't.